Yeah, we're going.
We're going?
Yeah.
Cool.
Okay.
How do you start?
We just did. I think we just did.
All right.
All right, here we are. So we are back, although we have a special guest. Brother X joins us again.
Brother X is back.
Yes, because Antushka is touring Europe right now.
Touring the nether regions?
He's in, yes, also known as Flanders, I believe. But it's cool because we're gonna kind of talk about what we wanted to talk about. I think what I wanted to talk about.
What you wanted to talk about.
That I kept trying to bully the conversation to be about. Yeah. And
now we're ready for it.
Yeah, and Brother X was very kind. Maybe I'll just call you BX.
BX?
Just for short, to actually pick something on it. So we're talking about intellectual property and specifically an article from like 2002. I don't know. Do you want to? Carla Hess is the author.
Yeah. I have no idea who this woman is.
Okay, well, it's called The Rise of Intellectual Property, 700 BC AD to 2000 AD. So basically 700 before Common Era.
Right.
To now.
Yeah. I mean, it's basically just an overview of how we got to where we are with intellectual property law.
But you don't know who Carla is.
No, I mean, we knew we wanted to talk about this, and I did some Googling.
No, I know.
Extensive research, and this article popped up.
Yeah. And actually, the whole journal, because it was a journal that you sent me, and the whole journal was actually pretty intriguing. So the next week, so Antushka's gone for 2 weeks, so the next week we will discuss another one from that journal. Let me find the name of the journal. But yeah, if you want to say something.
What is it?
Something.
Daedalus? How do you say that?
Yeah, but it's also...
Daedalus? Oh, the Journal of American...
Yes.
Journal of the American Academy of Arts and Sciences.
Yes.
Yeah.
But
they have their artsy name.
Right.
Daedalus.
Yeah. They think they're so much better than us.
They do, and they probably are.
And they are, yeah.
But I want to give you this... Plant the seed with this little quote first.
God.
I don't know if we'll come back to it or not, but it seems fitting.
Okay.
I was listening to a podcast over the weekend. Am I allowed to talk about other podcasts?
Of course.
All right. It's Fried Zakaria.
Okay. I'm familiar.
He was interviewing Stephen Breyer. You familiar with that guy?
I'm actually not.
Former Supreme Court Justice.
Okay.
Stephen Breyer.
I should probably know him. I thought once you were Supreme Court Justice, you went till you retire.
You have a lifetime appointment, but you can't. You are allowed to retire. You do not have to die.
Yeah,
as a justice.
Yeah,
but
RBG she just
Yeah,
she wanted to.
She did that.
Okay, moving on.
Moving on. Stephen Breyer, still living. Former Supreme Court Justice. So the interview was not about what he thinks the purpose of law is, but he gave this statement on, in his view, what the purpose of law is. And so he said, more or less, I just wrote this down after listening to it. He said, law, it is an institution created by human beings in large part to allow human beings to live together more peacefully and productively. And so I'm just putting that out there because I ended up, while reading this article, coming back a lot to sort of, this is like sort of the history of our conceptions of intellectual property, right? Going from, as you said, 700 BC up till the present day. And so it touches on both sort of like some of what the actual laws are and how they've developed over in particular the last 200 years, but also like the philosophy behind how we came to that law. And obviously a lot of those laws, there's sort of it's a lot of using the philosophy to justify what somebody needed, right? Mm-hmm. And so again, it just kept making me think like, what's the purpose of these laws? And if you take Stephen Breyer seriously, it's just to allow human beings to live more peacefully and productively. I don't know if that's always the case, but it was in my mind as I was reading this.
Yeah, no, I like that, and I think that does especially what you said about the philosophy, using the philosophy to sort of make your case. I think that's a really good point because that's definitely evident in this article, whereas I feel like the utilitarian argument, which we'll talk about, which, you know, the need of the many outweigh the wrath of Khan argument, if you will, the need of many outweigh the need of the few, was used to justify both sides of the intellectual property debate at one point. Yeah,
I think that was actually one of the most kind of interesting things to get at is sort of how those different philosophical viewpoints kind of played on different sides in different ways at different times.
Yeah, man.
If I can say nothing at all.
No, I think you said it all right there. And yeah, so I mean, so just you know, I guess to sum it up, if I could
go for it.
Basically, it seems like intellectual property really in its modern form started with the English, although, you know, the first, I think, documented conception, really, I think she puts it at the Chinese back in the 800s. But in terms of, like, you know, in the West, the English were the first ones to really codify intellectual property in the law, and that sort of ended up affecting everybody else. In, you know, continental Europe, it sort of trickled into them, like into France and then into Germany and et cetera. And it was really this sort of, I would say, at least the way she paints it, it was this fight between natural rights and utilitarianism for intellectual property. At least towards the end of the article, she was kind of painting it like that.
Yeah, she really sort of singled out kind of those two sides of it.
With natural rights being the idea that so intellectual property is a natural right and this comes from Locke, and actually, so anybody that's listened to the podcast, we actually talked about the exact treatise that she discusses in here, his second governmental treatise. We read it, Antushka and I, back like a few months ago. And yeah, the whole idea that basically if you make something with your hands, that's your property. And so that was then extrapolated into, like, if you think and basically put your personality into words, that's your property. And so that's the natural rights argument. And then the utilitarian argument is the opposite, kind of that it's like, well, for the betterment of all humanity, we should be making things more available. And thus, you should be basically open source. Think the open source argument of today in, like, coding and stuff.
Yeah. And
because that's how everybody will learn more if everything is open. So anyway.
No,
that's just a quick summary, I would say. But please add to that.
Spot on. And I think sort of one of the things that really stuck out to me as I was reading this, and she does make it clear in the beginning that she is looking at this sort of through the perspective of kind of literature, you know, specifically like authors' rights, literary property. And so a lot of this sort of philosophical debate, I think, stems from just the old notion of, like, sort of what do you do with knowledge and how is knowledge held up, right?
Great point. And where does knowledge come from?
Right.
That was the first thing she was talking about.
Where does it come from? And so the thing that I kept thinking about, because obviously I'm looking at this, obviously to your listeners who know me so well, I'm looking at this through the lens of a musician, where it's like, okay, you know, at some point when you get into now intellectual property, there needs to be some sort of categorical distinctions, right? Like, music is not knowledge in the same way, you know, to get back to, again, like you're saying, how she started with sort of the ancient Greek conception of this. You know, they're looking at knowledge as coming from the gods, and poets, philosophers, basically just transmitting what the gods are giving them to the people. And so, you know, she specifically, like, references Socrates, you know, holding the sophists in contempt for charging fees for learning, because knowledge was supposed to be free for everybody.
We also talked about that, too.
Did you?
Yeah,
Who did?
We did, because we read the Socrates defense, and that was one of the things he talked about, is how it was bad. But yeah, sorry.
So tell us your thoughts.
No, I mean, I think that it's I remember when we read that, I thought it was interesting because, it's like, also, sorry, if the sound just changed, I'm realizing acoustically it sounds really bad when I sit here. We're actually doing the podcast in person, because I'm in Chicago,
Wait, you can tell the people where you are?
I can. They just won't know who I are. But yeah, so sitting here with brother who's my actual brother. I think we also said that. But yeah.
BX.
Yeah, the BX. But yeah, I thought that was kind of interesting. And I think that generally I don't agree because, okay, so we were going to say this. The other thing that she outlined in the beginning more so is that you're right, is like a lot of this debate centered on where is knowledge from. Right. And so the old world thinking, and this is another thing that, it's just interesting. This is actually one of the reasons I really like this article because it actually tied a lot of things that Antushka and I talked about because it's also reminded me of Rose Wilder Lane's book that we read, Discovery of Freedom. Because it's this idea of the old world thinking was divine rights of kings. It was God. God is dictating everything. So the old world thinking for intellectual property was it doesn't really exist because it's not yours. You're an antenna for God's voice, and then you're not actually coming up with the idea. So that was the old way to that I guess you could say the vanguard would argue that intellectual property shouldn't be legal because you can't own anything if it's not actually from you. Right. The other way of thinking then is the Lockean thinking, which he outlines in his a theory of human understanding, which is basically the idea that the ideas come from the association of the mind, and thus your ideas are yours. Actually, they're not coming from God; they're coming from you, and thus. This is, again, the justification that if you make something, then it is yours. And so that was a lot of, I think, the arguments that were made for, you could say, the natural right idea of property was that, in the case of books, for instance, the reason why the author should get publishing rights, because actually historically, as Carla Hess tells us, authors wouldn't get publishing rights. The reason that they should is because they're actually imprinting their own personality onto the page, and so yeah. Anyway, okay.
Yeah, no,
there's a lot there, but the main thing that is just the idea that where does knowledge come from, and so the way to argue for intellectual property, I think in order to do that, you have to already think that knowledge doesn't come from God, it comes from you.
Right, yeah. And
the presupposition.
The presupposition. And you can see even like, where was this? Like, even after that idea, like, post-Enlightenment had become more or less established, there was still some tension in terms of how it became legislated.
Yes.
And so... where was this?
Are you? Yeah, because are you talking England or France? Because yes, you're right. So like the first, so we should say if we want to do it historically, the first real law was in the 1500s in England, at least. There was a law in Venice before that in like 1480s, but in England, the first law for publishing rights was, I think, under Queen Elizabeth, and it basically gave them a monopoly to to just a few people, and it basically said that nobody else could publish things like the King James Bible. So only one person in England was able to publish the King James Bible, and only one person in England was able to publish like the Psalms or something like that. And nobody else could. And so basically the point is the first property rights in England, the laws governing property rights was that you don't have them. And then 150 or odd years later, you have the bloodless revolution that established the constitutional monarchy in the end of the 1680s into the 1690s. And that was then when you got the first natural rights property, which makes sense too, because Locke just published his thing, and that was basically establishing that the author would get, I think it was like 7 years or 14 years or something like that, but it was the first time that there was like the author would have publishing rights, and also it would have it for an amount of time, and they could also sell these rights. But that got changed a lot in the next 100 years, and I don't know if that's what you were getting at.
That is what I was getting at, but actually from where you're starting it, I forgot about this, but the thing that I thought was really interesting about just that first law in England is, because as you said, like Locke hadn't published yet, he wasn't around, and so that idea wasn't really fully formed yet of that this knowledge can come from the authors. And as you're talking about, it's more about like who gets to print the Bible, which obviously people were thinking came from God, not from people. And so those early copyright laws, it wasn't about intellectual property rights and who owned the rights to that idea. It was about who was controlling the flow of those ideas and the dissemination of them.
Yep.
And that's definitely something that's been part of it.
Censorship.
Ever since.
Yep.
And like you said, so it was just sort of a few publishers that had this monopoly, and it's clear that, publishers and those with power have been, fucking people over for centuries.
Well, and this was, it's jumping ahead a bit, but I think it's a good thing to bring up now because it's an important point. I think a big one of her, maybe her thesis, it seemed, or at least certainly the most interesting thing that I took away from it, of a point she was making, was this idea that you would actually have people choosing natural rights, the natural right angle or the utilitarian angle based off of if they were established or not. Right. So the point being, Europe, and she broke it down even more fundamentally in that if you're exporting intellectual property, you're going to be for the natural rights perspective. Right. And if you're importing intellectual property, you're going to be part of the utilitarian. So Europe was the first big exporter of intellectual property. Yep. And so they were, of course, also the big proponents for the natural rights. Yeah. America in the 19th century was a big proponent of the utilitarian method. And because you had this whole bootlegging operation of people on the East Coast, publishers basically stealing, essentially, English novels and just writing, publishing them and selling them for much cheaper. So I think she used an example. You could get a Dickens novel for like $3 in England, but like a few cents in America. Right. But then comes the 20th century, the U.S. starts to export intellectual property because they're becoming we're becoming a power, a major power, and then we start to become, of course, more natural rights oriented. And now, it's just making me think about us in China. We have this whole thing about like we want to keep our protection, whereas China keeps stealing a lot of intellectual property. Yep. I guarantee you, then, if this hypothesis holds, then in 100 years or something, China's going to be purporting the natural rights philosophy because we're like, hey, we need to protect our property.
And I think that was sort of a really interesting thing because, like you said, when she distills it down to whether you're an importer or exporter of intellectual property, that's really what's more important because for the first like couple hundred years, it often looked like the publishers were on the side of not the of the utilitarian view in the sense that because the publishers weren't the authors, they wanted to protect the rights for themselves and not give the rights to the authors. But then, like you're talking about, in the 19th century, there were American publishing houses, and they were trying to import these books, novels, everything from Europe. So they wanted to sort of weaken. They didn't want to recognize European copyright laws because they could then just steal these books, republish them in America, sell them for cheap because they didn't have to pay anyone anything else. Right. And then in that situation, it was the authors who became. Well, obviously, authors are often on the side fighting for their natural rights, but the authors were fighting for it. And in this sense, it was not only so that they could earn money off of their publications, but even just that an author couldn't get their own thing published and be owed anything. In essence, it was like importing a product without a tariff, right? Because now European intellectual property was selling cheaper than American intellectual property, and so that was just.
Oh yeah, I didn't think about that.
It was it was such a weird way to look at it. it's like as an artist, you're taught to not commodify like art, but it really put it in that perspective for me really clearly.
That, actually. Yeah, so you're saying it's sort of screwing over the American artist because the European art is selling for cheaper.
Right.
Yeah, that's interesting.
Yeah, and so let's see. So she quotes, there was some dispute going on in the mid-19th century. Let's see. Not surprisingly, despite repeated petitions to Congress from distinguished writers in both America and England, this movement was repeatedly thwarted by more intensive lobbying of the American publishing industry in the name of the public interest, the utilitarian perspective.
Right.
Thus, the Sherman and Johnson Publishing House of Philadelphia sent the following protest to the Senate and the House in 1842. And so in this, they specifically use the word tax. That's what kind of caught my eye. What this publisher sent to the Congress was, all riches of English literature are ours. English authorship comes to us free as the vital air, untaxed, unhindered, even by the necessity of translation into the country.
Yes.
And the question is, shall we tax it? And that's the thing is once you start, it undercuts what an American author can sell their work for. And it's a little bit apples to oranges because, an American author is writing something different from what you're importing from England, but somebody will still look at two books on the shelf next to each other and say, well, why would I pay this much for a book when I can pay this much for a different book?
Right. Yeah, actually, I think that's a great point.
Yeah.
Yeah. Dang.
But yeah, it's like the other thing this article really got me thinking about a lot too was, and she does touch on socialist countries a little bit at the end, but she doesn't go that in depth. And just thinking about
although the Marx point was something we should highlight because it was interesting.
It was, and we can get into that. But most of this, because it was focusing on kind of in particular European laws and statutes that got passed. It's looking at how you sort of view ideas, intellectual property, non-tangible goods within a capitalist society, right? And that kind of structure. And
right, which is why I wanted to initially talk about it, because we're musicians, and so I think honestly, the big story when I first wanted to talk about it when we were discussing intellectual property rights was Ed Sheeran was battling this big case. He was being sued by somebody's family. I don't remember who. But anyway, they lost because they were trying to make the point that, basically, I think what was most similar between the songs was the harmony. And so that's one thing that it seems that the industry and lawyers have agreed that you can't copyright harmonies, which makes sense in my head.
Right.
But melodies you can copyright essentially.
Yeah.
Essentially. But even that, I feel like it can get kind of tricky because it's
right.
Yeah. So, it's just very interesting because then I start to think about it kind of mathematically too. There's probably a formula of there's things in math, correlation coefficients, which sort of measure how much things correlate, but you could say it's a measure of similarity. And it was just making me wonder if you could do that for this. Anyway, that's a different, but because
I think that's completely related.
Well, it's related, but the point is, it's that I don't think we do think about it that quantitatively, though.
We don't. And
maybe we should be, though.
But that's exactly, I think, where the crux of it lies, though. Early on when the author here is establishing the kind of natural rights philosophy and the foundation for that, even, aside from Locke, she also references, where is this?
For the natural rights, Young.
No, wait a minute. Sorry, I'm in the wrong spot. I gotta find what I was talking about. But it was somebody who's talking about sort of a unique expression, right? And that's sort of what it's about. And it's early early as like the philosophy was sort of, as people were sort of understanding that ideas might come from people and not just from God, it's like trying to figure out, how do you
It was probably Jung's conjecture.
maybe,
right?
Where is that?
So 34, about 33. Because the other person, that came after Locke in like the 1750s was Edward Young, conjectures on original compositions.
Okay.
And yeah, I mean, according to Young, the labor of an author was thus of a higher order than the labor of an inventor. Sorry, I just kind of jumped into into a random thing. That the author contributed more than simply his labor to a book. He imprinted its contents with his original personality. That was the point I was making. That it's like, yeah. But maybe you're thinking of Diderot. He was the French guy who was making the natural rights points.
What was this? What am I looking for?
Diderot was he said, what form of wealth could belong to a man if not the work of the mind, if not his own thoughts, the most precious part of himself that will never perish, that will immortalize him? What comparison could there be between a man, the very substance of a man, his soul, and a field, a tree, a vine? Now I know he's French.
Wow.
He's talking about vines that nature has offered in the beginning equally to all, and which the individual has only appropriated through cultivating it. Yeah. It's a very French way of saying that.
It's a very, what was I thinking of?
I don't know.
But, so, I don't know. If I can find it, I'll bring it up. But the idea was just sort of that a lot of different people might have the same ideas, right?
Oh,
so
yes.
How do you assign sort of the right to an idea? And this philosopher was saying, well, it has to do with sort of how they basically end up putting it into something tangible, and it's that unique expression. And
you're probably talking about Johann Gottlieb Fichte, maybe?
That could be. Where is that?
Page 35.
35.
The disciple of Kant.
Okay.
A great many people seemed able to share the same ideas, and it seemed intuitively just that as many people as possible should be permitted to express freely the same ideas independent of one another. Fichte's solution to his puzzlement proved widely influential. For an idea to be regarded as a piece of real property, Fichte argued, it had to be assigned some distinguishing characteristic that allowed one person and no other to claim it as his own.
That's exactly what I was thinking of. Yep. So yeah, and then just further down, right? So the quality doesn't lay in the ideas per se, but rather in the unique form in which an author chose to express these ideas, right? And so, to your point about like music and harmony, you can have the same chord progression, but what's the sort of unique expression of that chord progression in a song?
Right.
And then I think even more to the point, there's some case that's referenced later on in, I think this is in probably 19th century America, of, let's see, on page 42, they're talking about the case, a court decision written by Justice Holmes in Blystein versus Donaldson, 1903. The case involved the commercial reproduction of images used in a circus poster. And the argument of the defendant, Donaldson, was that the images were of such generic nature as to contain insufficient originality to qualify as artistic creations susceptible to copyright protection. And the Holmes court demurred, arguing that the courts were not to be put in the role of literary or artistic critics, right? And so that's where we run into the issue with some of this stuff is...
How do you compare?
Right? And they ran into that exact issue in 1903, but I also love the concept of this isn't original or creative enough to qualify as an artistic creation. And, I love that concept, but of course, like, how do you legislate that, right?
And how, because, no, it's true. And how many people, I mean, because this is the funny thing is then, because, like, in some sense, you could probably say that a lot about a lot of the music that's out there.
Right. That's what I was sitting there thinking.
At, yeah.
Yep. But who gets to sort of make that decision?
Yeah.
Obviously, it's not something you could or would want to put courts in charge of. It would be a mess.
No, but I mean, like, I'm just even already thinking it's just we have. Yeah, I mean, yeah, I don't know. I mean, so it seems like, though, the way that it's done right now, with obviously I'm not an expert, but if I were trying to compare two melodies, you're looking at the rhythm and the notes that are used and actually not even just the notes, more specifically the intervals, right? Mm-hmm. So rhythm and intervals is really like what you would be trying to judge it by. And then, I mean, you could probably just count those and then say, is it greater or less than 50% similar? And then that would be something.
Yeah. Yeah, I mean, there is probably a way to quantify it. And I guess the other thing is that when these things do go to court, they do bring in, like, expert witnesses, right? Like the Ed Sheeran thing, they had music theorists,
Oh, I'm sure.
Testifying.
People much more qualified than us.
Yeah.
Or not. Who knows?
Who knows?
Actually, I shouldn't see you're more qualified than I am.
I don't know.
To speak on this. You have a master's.
I have a master's. Yeah. But no, I thought that was
is very interesting. Yeah.
And it just like I think it's a really and this is what's so I think difficult with philosophy. And I guess like where law can get kind of interesting is how do you sort of take these, I mean, even the Stephen Breyer like quote I started with, like law is there, it's a creation of people to serve people, right? Mm-hmm. Like it sounds so simple and good, but it's like, okay, well, what does that mean, right?
Yeah.
And so when you actually put it down on paper, like to serve people, like even when you're talking about intellectual property, is it, in a lot of these cases, the argument from the utilitarian side against the rights of authors is we're serving people by allowing these ideas to disseminate, and those are going to like be good for society.
Exactly.
Right. And so that's one sense of serving people. When you talk about, music, what does that mean? Does it mean like I want other musicians to be able to, copy in some form or another to maybe it's for dissemination, maybe it's for just sort of creative proliferation. Like, where do you sort of strike the balance, especially when you're getting to more entertainment fields? And that's not to diminish music, but we're not talking about like a copyright on medicine here.
Yeah.
Like let's be real about it. Yeah. So how do you like what's sort of the case for what serves people in that realm? Like I don't know if you want to speak for Antushka at all, but I know I
would love to.
My recollection. Try to speak very carefully here. My recollection.
He's gonna sue us if we're not careful.
He might. You know what? Come after me for my millions, Antushka. Yeah. I dare you.
Yeah.
My recollection is that Antushka's feeling is that copyright law in music, as it stands today, is too inhibiting for creativity. And, well, not even necessarily for creativity, but even just for, I know he was bringing up a case of, like, even for educational use that, like, you can run into issues of just playing stuff in a classroom and, so in terms of, again, this question of what's the law in this field, in this area that's going to serve society, serve people, while also allowing artists in a capitalistic society to make a living off of their work,
Yeah, no, I mean, I don't know exactly how he would feel, but one thing I do related to this that I think that he would say is this idea that a lot of these things are in place, a lot of these laws are in place not for the overt reason that we think they are, but for actually just the powerful to retain the monopoly, which is, why, going back to the point of the publishers, right? They switched from, all they really wanted was to make money, right? So they were saying, hey, we're utilitarians, we want just the best. But then, of course, once they make all of their money, now, and they realize now they actually just want to consolidate the ability to publish things and monopolize it.
Well, she showed like specifically how that shift happened, where as American intellectual property was growing, the other thing that the East Coast publishers realized was that if they suddenly struck up a deal with European publishers, they could then be the sole publisher for a European work in America.
Right.
So like you said, it was always a money grab for them.
Right. Right. Yeah. So, and that's something we've talked about previously, which I think was a good point he made, is that just a lot of the things that are in place, because I mean, generally he just thinks there's too many laws, and a lot of the laws that are in place, again, they say that they're for an overt good reason, but really they're just shielding a powerful person to allow them to consolidate.
Right.
A monopoly. So, but yeah, I mean, I don't actually. It's a good question, and maybe I'll get them to comment on it.
I think we should do the rest of the podcast of us speculating what Antushka would think about various elements of this reading.
Not a bad idea. And maybe one of us could even try an impression. No,
I'm going to leave that
to you. No, but yeah. So the Marx angle though was very interesting, because it was at the very end, and you're right that it was kind of said in a passing manner, but it was so it's basically saying that Marx argued that labor was inherently social. Right. Rather than individual, which I guess makes sense. And honestly, I kind of agree with this in some sense, because
I do too.
He's saying, that the individual is molded in society.
Right. It's saying, yes, this idea came from your head, but you are who you are because you live in the society with everyone else.
Yes. And this was actually a point that I had made to Antushka when we had our anarchy debates.
Yeah.
Because a lot of his argument rests on the idea of consent, just generally about just the consent of the governed, right? That's where a lot of the anarchy arguments lay, which I completely agree, but also there's so many things that are non-consensual. And again, we're not...
Especially in the nether regions.
No, every time we bring this up, because consent obviously is such a freaking loaded word now, not talking about sexual consent, where it's always necessary, okay? All right, but no, we're talking about like in the case of life, none of us consented to be alive. You know what I mean? That kind of thing. And and Locke sort of makes a lot of these points in his second treatise of how you really are under, you are not a slave to your parents when you're growing up, but you are under their dominion, right? For good reason, because you don't know anything until you do. And when is that? Who knows?
Until you think you do.
Or until you think you do. And then we die.
But I mean, that idea of just, an idea is it's an individual creation, but it's born out of their place in a society. Again, it can sound like, okay, what do you do with that in reality? But when he's sort of bringing that, or when she's bringing that back to just, I guess, some more kind of real practical application, and she talks about the Cultural Revolution in China. Mm-hmm. And there's this quote that she's got there. Is it necessary for a steel worker to put his name on a steel ingot that he produces in the course of his duty? If not, why should a member of the intelligentsia enjoy the privilege of putting his name on what he produces? And it's just, again, like I think any analogy is always going to fall short at some point. But I think it's a really powerful analogy that should, and at least for me, it made me really like think about, okay, why should somebody have ownership over this versus that? Like, I think it's a really powerful comparison.
Yeah, no, I agree. And because in the Lockean perspective, he sort of does have ownership over that. If you take it to be very specific, or I mean not specific, very what's the word? Direct, when he's saying whatever you manipulate with your hands is your property.
Right.
Yeah. But yeah, no, I mean, I agree. It's yeah, and this is why it's been debated, right, for millennia, and why, and so, and get like, if we sort of jump back a little bit to the first debates that were occurring, that was kind of, again, that's kind of getting, it is showing how you can come at this idea of knowledge isn't yours from, you don't need God for that. Because in this case, in the, I guess, the Marxist communist example, God is just replaced with society.
Right.
So, but it's the same idea in that knowledge isn't yours, and you don't. So, and you know, there's something to that, which is why I think obviously the best thing is always a compromise, which is why in some cases the system we have now I am pretty happy with. I honestly think 100 years is a bit much, because what's the system now? It's 100 years and then everything's in the public domain, right?
I think for music it's 75.
75, okay.
But it's still a long time, because it's 75 years after the author's death.
Yes.
I think.
Yeah.
It's a long time.
It's a long time, and in my idea it should be maybe just like a generation.
Yeah.
But that's like 3 generations.
I'm trying to remember, again, I think it was in passing, maybe it was like, she touches really briefly on like some of the Islamic countries at the end.
Right.
I can't remember, but she mentioned one, maybe it's like Iran or something, where like an author has ownership of it for a period of time, and then after they die, it goes to the ownership of the state before it goes to public domain.
Yeah.
You know, so I don't know. There are like sort of different ways you can structure that.
Right.
And
yeah, England had like 14 years, and then you could renew for another 14 years.
Yeah, I think that's what it was.
And then it would be public domain.
Yeah. And
that's actually in my head more reasonable.
Yeah, I think so. And it's like, if you can't make money off something in 30 years, you know.
Yeah.
I don't know.
And that's actually how we do it the
royal we.
Yeah, the royal we. Not even though. No, not the royal we. I'm not talking about me. But that's how the pharmaceutical industry does it with drugs, is that I think the patent for a drug is like 10 to 15, 20 years.
Yeah,
it's
shorter.
I can't remember the exact date, but it's 10 to 20 years.
Yeah.
And yeah.
And so again, I guess like the difference is still, people are trying to think about the comparisons to physical property, right? And so I don't know like how you would weigh something like this, but again, because acknowledging that there's obvious differences between, say, music and like a patent on a medication that might be really important. It might be really expensive until it's in the public domain. But you know, I think one of the arguments for having a longer copyright on certain intellectual property, a longer author ownership that can be passed down to their heirs, their estate, is that's a way for someone to create generational wealth for their family, right? The same way that they can build, you know, a business or, you know, a real estate.
That's exactly, I think that's exactly why. Yeah. But I think that that's stupid. I think that, you're going to raise better kids if they're not dependent upon the inheritance, right?
Well, and then I also think about, you know, is there an argument for, if you're talking about any kind of public good argument, actual public good argument, not publishers, you know, hiding behind a public good argument.
Right.
Is there a public good in terms of, like, the balance between you want to support an artist who creates something that the public deems valuable, and you want to support them to be able to continue to do it, right? So you want them to continue to profit off of it. But you also want to encourage them to keep creating and not maybe just rest on those royalty checks coming in decade after decade, right? So is there a balance there between, it's like, well, you got, 20 years, 30 years, whatever to profit off of this, but you should keep creating.
Yes.
Yes.
Yeah, and actually, you had said you think 30 years is long enough. I actually think that it should be longer for.
Okay.
I actually kind of agree. Like maybe while the artist is alive, they have the rights to their stuff. But as soon as they die, to my head, it should be everybody's at that point.
Yeah. So, I don't know if this is even playing devil's advocate, but could there be a situation in which somebody had so much music that everybody wanted that there was then an assassination attempt on that person so that their music would be released to the public domain?
You referring to John Lennon?
Is that...
No. I mean, yeah, I suppose it makes that incentive.
Yeah, probably highly unlikely, but...
it's a good point, though.
I'm just trying to think about consequences of a...
Yeah. No, I mean, that's a good point. And you run enough cases at one time, that's probably going to happen.
Right, yeah. But what was I going to say? Yeah, so another thing, though, that came up here, and I think she touched on it a little bit in the Marxist discussion, but also, obviously, like, sort of capitalist, like liberal society, when you had monarchies, another thing that you had was like patronage systems. And I can't find it now, but I think there was some discussion of what was effectively state patronage for, creators of intellectual property. And I think we see that...
That was during the French Revolution, right? That stuff was...
That might be...
It was Cataracts.
I don't know. Condorcet.
Yeah, Condorcet, that's what.
Yeah. Cataract.
I don't know what the hell I'm saying.
Yeah, all right. So page 36. While Diderot, Lessing, and Fichte celebrated romantic originality, Condorcet sought to ground public literary culture in scientific rationalism. Yeah.
In the scientific rationalism,
the model of publication based upon authors' property rights could, according to Condorcet, be replaced with the model of periodical subscriptions.
Right.
People could subscribe to useful publications, and the authors could be remunerated as salaried employees or freelance writers. So,
yeah,
I think this stuff kind of happens in music, but I think that's also in realms where we would sort of view it as maybe less groundbreakingly creative.
Something is rattling. I don't know what it is.
Something's rattling.
I wonder if it's Yeah, it's the chord hitting this.
Oh, so I can't rock. Okay. Anyway, I was just trying to think, like, if that's sort of a different model. Like, it makes sense. Obviously, we do have that model in writing, right? There are still periodical publications, and there are salaried writers, and that's intellectual property. And I actually don't know what those contracts look like. I'm assuming, like, if you're writing for a newspaper, for a periodical, you're just getting a salary, and I don't know if you own your works for reproduction or if something gets picked up by a larger. I don't know how that works, but we have that model in certain fields.
Yeah,
does that function in music?
Yeah, that's an interesting point, because I was thinking I can kind of see it in writing, like with Substack. It's basically what you're doing.
Oh yeah.
You do Substack.
Well, and I guess maybe then there are some musicians that do things through, like, Patreon.
Well, in a sense, it's kind of what we're doing with Spotify. Kind of.
Well, no, because this is talking about subscription, but then being salaried on the back end.
Yeah, we're not getting a salary.
Not getting a percentage.
I should be.
You should be, yeah.
We should be.
Yeah. The only example I could think of, and I haven't thought about this deeply, but the only example that pops into my head is
Substack's not doing that either, of course.
Yeah, that's very true. Off the top of my head, there are some like what would you call them, like media companies where like they make ads. Mm-hmm. And they would have like an in-house composer, musician, whatever, to create custom music for ads. But now we're not talking about somebody who's putting out like a top 40 hit.
I was thinking about that too. Or movie like studios will have just composers, right?
Yeah. Well, yeah. I don't know if they're salaried though.
They might not be. But
and so in terms of like creative work of what people consume musically as music, not music that's accompanying something else.
You're just reminding everybody why it's so difficult to be a musician, because there's the idea of a steady paycheck is so difficult.
Well, and that, but you know, so I mean that's the thing.
Because that's really all we're talking about, though, in some sense, is a steady.
It's like if you're going to do this intellectual work, how do you, in a capitalist society, support yourself to be able to do it? Right?
Yes,
that's what this. I mean, that. Yeah. And if you get back to Stephen Breyer, like, what's the purpose of these laws? Yeah. It's to, you know, in large part to help people live together more peacefully and productively. So, as a musician, you know, and again, it's just getting me to try to think, like, is there sort of a different model for how to support musicians? And I don't think that there is. Or at least we haven't seen it yet.
We haven't found it.
Right, because you'd have to have some sort of central organizations where it's, I'm subscribing to Spotify or I'm subscribing to Spotify Classical, you know, $5 a month, and they have salaried composers, artists that are creating and releasing new music on a periodic basis. Yeah. But it's not shitty music, right? It's not ad music. So we did used to have this. When?
Bach. The courts.
That's what I'm saying, the patronage model.
Oh, sorry, you said that. Yeah.
This is the patronage model. Yeah. But now we're talking about we don't have patriarchs, right?
The courts. There's no courts.
So it's how do you sort of translate that to?
You just want to be a court musician, is what you're telling me.
I mean, it would be a pretty cushy life, right?
Yeah, it would be.
Are you telling me you don't want to be a court musician?
Bring the Habsburgs back. Where are they?
Yeah. I mean, listen, like the courts, like you talk about the European Enlightenment. I mean, the people that they patronized drove a lot of a lot of stuff.
Right. Yes. No, it's true.
The Florentine Camerata.
Of course.
Come on.
Of course. But also
Galileo.
Yeah, I know. I agree. A lot of great music. But you know, once they broke free of that in the 19th century, they did some good stuff too.
They did. Yeah. No, they absolutely did.
But you're right. And yes, I actually think they did better stuff once they broke out of it. That would be my.
I haven't thought about it.
Yeah. Because, like, in terms of what I listen to more, I listen to a lot of Bach.
Yeah.
But I think I still listen to more, maybe I listen to more Bach than Beethoven.
I definitely listen to more Bach than Beethoven.
Okay.
But I think of any sort of singular artist, Bach is probably the one I listen to most.
Yeah.
But on balance, I don't listen to more Bach than contemporary music.
Yeah. Yeah. I've actually been listening to more Beethoven just because I've been trying to go through his sonatas.
His sonatas are pretty great.
What's his name? Artur Schnabel.
Schnabel.
Yeah.
Yeah. No, the sonatas are pretty great.
Yeah. But yeah, no, your point's taken. It's interesting. And actually, what you're getting at was just making me think more about the interesting point what's the guy's name again? Catarat? What's his name?
Condorcet.
So he was writing during the French Revolution. So it's interesting, too, that he, the subtext to all of this is something I think we've also talked about previously, is the idea that you have this, this is something, so we broke this episode into, we just started talking about Foucault. And Foucault's big thing in all of his books is that you had basically a big change in the Enlightenment, right? Everybody talks about that, but he does as well. And specifically, you have this rise of the statehood, right? You have these giant states, and you have this flip. This is actually a really interesting point that he made, that now I'm like looking at everything with this viewpoint. They had this flip in how they were then thinking about people because of capitalism. It was a pro-life instead of pro-death sort of mentality. Like you wanted the populace to live now, whereas it's like everybody was just kind of trying to survive before.
So you could exploit them more.
Exactly. Because that's exactly it. It was this perverse incentive where you wanted them to be healthy because then they could work for you.
Right. That's why employers offer health insurance.
Right. Exactly. Right. But yeah, and so the French Revolution was a very good manifestation of that. They were thinking about, like, do we have this new thing where the state now, we're no longer a kingdom, and so they were rethinking everything, and it was always to this idea that you'd have like a centralized council, and it would be and it makes sense to me that you would have they'd be talking about salaries and stability, because it was all about that, creating this very stable apparatus. Whereas in some sense, then you have the English system, which was a little bit more anarchic, is that you had they called them the nation of shopkeepers, right? So you just had a bunch of people, a bunch of publishers. But anyway, I'm getting off on a big tangent. All I wanted to say, though, is that it was interesting to think how. What was my point? I think it was just the pro life point. God, what the hell was I trying to get at?
Enlightenment. You're in the middle of Foucault.
Yeah, maybe I just wanted to say all those things.
Yeah. Right. Do you feel better now?
No, I don't. Okay. Yeah.
All right.
Yeah. What the? I'm gonna cut that out. I'll cut all this out. This whole episode's gone now. No, I'm just kidding.
Quick tangent based on Beethoven's sonatas. And this seems really obvious to me now, but when I was in grad school and I was studying sonata form and going through Beethoven's sonatas, the thing that was really interesting to me is, like, and this is the thing that I think is always, for me, a tension between, like, philosophy and practice. You study something, and especially in classical music school, you study something in theory. You learn about what sonata form is in theory too, right?
Yeah. Just one. Every time this like rubs up against something, it makes a sound. That's the problem.
When did you learn about sonata form?
I learned
theory
about sonata
one, theory
form, probably theory one.
Right? And you learn
antecedent consequent.
You learn the formula. You do this, right?
Yeah.
And then we're going through Beethoven's sonatas, and every single one of them breaks from sonata form in some way. And the reason is because there was no textbook telling Beethoven what sonata form was.
Right.
Like, people are writing things and calling them sonatas, and they're generally doing the same things. Just like,
trap music.
Just like trap music. Yeah, sure. I don't know enough to comment, but just like somebody could say, I'm going to write a refrain style song. And there's certain things that make it that, but everyone does something different, because when you're writing a song, you're just writing a song, right? And so, but just that idea that, like, we can learn about the theory, but then the practice is messy, right? And just
practice is always messy.
Practice is always messy. And it's like all this stuff about copyright law. Like, I mean, early on, she talks about how it has to do with, like, epistemology, but it also gets into, and this is why I loved looking at arrangements and why I wanted to read that other book with you and Antushka a couple months ago. Is like, looking at arrangements, like, you're looking at, like, the ontology of something. Like, what is the actual thing when it's not physical? Right. And when you're trying to give somebody rights to something, you have to understand, like, the boundaries of what it is and what it isn't. And it's really messy in practice, and especially when you talk about that ideas can be knowledge versus entertainment. Right. And I'm sure there's other categories if we really wanted to parse it out. But, there's just so many ways to look at it and cut it up. And man, it's complicated.
Yeah, no, I agree. And I think that's why, also just to do the callback to before, I think that's why, as she documents, you had people arguing for and against property using the utilitarian angle. Mm-hmm. And so correct me if I'm wrong, but the people that were essentially using the utilitarian angle to argue why you shouldn't have public property was like the Elizabethans, who were saying that it was sort of the good of society that they had censorship.
Yeah, I mean, I think, and yeah, that
and
does,
monopoly.
But that actually, like, that absolutely brings it back. Like, early on, it was about censorship more than sort of the owner. It wasn't about the ownership of those ideas so much as the dissemination of them.
Yes, and it was dissemination for the good of society. That's the point.
Exactly, right, exactly. It wasn't just like they're trying to control it, but it's like, this is the idea that people need to hear about.
Yes.
And, you know, and that really did stick with them for a while. Like, even when she's going through these court cases in England that are really sort of crystallizing our modern conception of intellectual property right, she talks about this one case, Donaldson versus Beckett, which was, what year is this? 1774, right? So it's still like we have this concept. When did Locke publish?
16.
Right. So
90s.
Yeah. So we're 80 years past that. Like, we have this concept of sort of it belonging to a person. There's other court rulings that are giving these rights to the author, but in Donaldson versus Beckett, you know, she says that it established the encouragement of learning as the highest aim of the laws regulating books, right? So even though they're giving these natural right? Copyright was acknowledged to be a natural right rooted in common law, but there's still this limit on it because they still want it the encouragement of learning, right? That's the public good that they still think is crucial to this.
And I remember what my point was. The rise of the state is the rise of the public good. And I think you see that it makes sense, too, that you have this utilitarian idea in the Elizabethan in England, too, because you had Hobbes' Leviathan was published in that,
Leviathan,
which is the public body. That's the big state that he's talking about. The Leviathan is the state. Do you have that over there?
I thought I did, but maybe not. Did
Brother
you take
X is looking at his bookshelf. No, I didn't think we owned it.
I thought I had the Leviathan. Maybe I got rid of it.
Growing up, so Brother X is 5 years older than me, and so I would just steal all his books. And I would try to read them, and I would pretend like I understood them.
Yeah. You still have some of my books.
Yes.
Anyway.
I have the what is it? To Be or whatever it is.
The Courage to Be, Paul Tillich.
Yeah.
It's a great book.
Yeah, I tried.
Ontology at its finest.
You know, it's funny, I started reading it, and then he was talking about Aristotle, and I was like, I kind of want to read Aristotle instead. So I went and read Nicomachean Ethics, or whatever it's called.
Nicomachean? That's what I always called it.
You probably have the pronunciation better than I do.
Early on, somebody, like in high school, somebody gave me that book, Zen Guitar. I was really excited to read it, and early in Zen Guitar, I don't even know if that was the name of the book. Early in it, they're talking about the concept of Zen, and they're saying like something about like, you know, it's sort of focusing on the present moment and, you know, not getting caught up in things, but worrying about what needs to be done right then in that moment. And as I'm reading this, it was like summer break, but I was in a summer school class and I was like, oh man, I've got class tomorrow. I haven't done my homework. I really need to go do that. So I put down the book and went to do my homework, and I never picked it up again. Yeah.
Wow.
I never finished Zen Guitar.
Yeah. Wow. That's very, I don't know, is that Zen of you?
I don't know. But
that's Zen.
Yeah. Yeah.
But yeah, I mean, so that was the point that I was trying to make, though, is that the rise of the state and utilitarianism and the idea that you want people to live, then that makes sense why that you know, that theory that Foucault has that, you know, it went to a pro-life sort of mentality, sort of jives with that, and it in my head makes sense that you would have the rise of utilitarian philosophy coming. I mean, utilitarians really came into their own in the 19th century, but there was obviously still sprinklings of this. And in fact, David Hartley, one of my favorite philosophers, and I've brought up quite a lot on this podcast, but people probably still don't know who he is because, I mean, it's okay. It's fine. But I'm going to keep talking about him. He was actually influential for the utilitarians, and then you could say utilitarianism kind of came from Jesus. Like, do unto others what you would have done to you. No, that's not it. The hell am I talking about? I think we've probably...
That's utilitarianism.
Utilitarianism? No, but just the idea that you actually care about others, versus... Yeah. But then you have capitalism, which that makes sense that you're going to have Hegel's dialectic. So if you have one philosophy crop up, you're going to have sort of the antithesis.
Do I still have Hegel over here?
Oh, God.
I don't know. I got rid of books, too.
Yeah.
I'm pretty sure I
remember seeing Hegel, yeah. I don't remember ever seeing Hegel. Because I hadn't heard of Hegel until I don't remember when.
Maybe I'm misremembering. Is Hegel the phenomenology of the spirit? That was what I read by Hegel.
I think so, actually.
I must have gotten rid of it.
I forget. Were you theology in undergrad?
I was theology.
That's right, yeah.
After I graduated, they changed it to religious studies because they realized I was more reflective of what they were teaching us. But on paper, it says theology.
Yeah. Yeah, because you did a lot of philosophy, yeah.
There's a lot of crossover.
Frickin', what's his face?
Thomas
Aquinas.
Thomas Aquinas.
What did you say?
Nothing. That's the name of my teacher. Yeah, Thomas. So yeah, Saint T.
Yeah, I mean he was literally the crossover, right?
Yeah. Yep. Anyway.
Yeah, I think we've probably done it.
I think so.
Yeah,
we've beaten a dead horse.
Yeah, and I've made plenty of non sequiturs. Enough non sequiturs for anybody. But yeah, overall, I actually really enjoyed this. I just thought it was good.
I did too. And looking forward to. Wait, should we tease the next?
We could tease.
Let me find. Oh, you have it right there.
Yeah. Good. Richard A. Posner. The law and economics of intellectual property. We could probably add something. So, maybe we'll do it.
It makes more sense to me now. There's an article in here on Diderot and Condorcet.
Oh, nice. Yeah. Okay.
If we want to get more into them.
Into the French.
The law and economics of intellectual property. I don't know. We have so many options.
Yeah, so we may do the Posner
Freedom of the press.
Yeah. Yeah. So we'll
Pop music, pirate hunters.
Yeah, and I'll put the link of this in, I think, the bio. Or not the bio, in the description.
Yeah, it's a free PDF.
Yeah.
People can read it.
Yeah, published in 2002.
02.
We weren't even at war yet.
Wow.
I know. It's interesting. I always forget, we waited 2 years to go to war. I was just a young chap. Why are we talking about this?
I don't know.
Yeah. Where were you on 9/11, Brother X?
I was in high school.
Yeah.
OPA. Well, should I? No. I was in high school.
What class were you in when you heard the news?
I don't remember. So I remember hearing about it. I remember hearing about this is great podcasting. All right, never mind.
No, I want to hear.
I remember hearing about it during the passing period between periods 1 and 2.
Okay.
Because some kids I remember saying that they remember somebody rolling a TV in and they were watching it. Mm-hmm. What time did it happen?
Morning.
We started
9
at 8
or something. That would make sense.
So I remember I'm assuming it was between periods 1 and 2, but in a passing period going through the hall.
Oh, and they were it's Eastern.
And seeing one of my friends running through the hall, I don't remember what he was saying. I remember I didn't understand it, but he was basically shouting about what was happening,
Damn.
Yeah.
Yeah, because I just remember I was in 4th grade, so I just was confused. I was one of the kids.
Did they roll a TV into your room?
I might as well have been one of the kids Bush was reading to when he was there's that scene of him.
Oh my God.
And then he just keeps reading. What are you gonna do? Yeah. But yeah. So I just remember being confused.
Did they roll a TV into your classroom?
No.
I don't remember being in a room where they were
if they did, I don't remember
broadcasting it. But I know kids were saying that that happened at
That would
my
be
high school.
crazy if they did it for us, though. Elementary school.
Yeah.
Hey, kids, come, let's watch.
Let's watch this.
I mean, that's crazy that they did it for you guys, too, in some sense.
Yeah.
They had you watch film of the
I mean, it was the live
towers?
news broadcast.
Oh, okay. Okay.
Yeah,
that makes
it was
more
just
sense.
the live news.
Yeah, CNN or whatever.
Yeah, that was covering it.
God.
But I don't remember watching it. I don't think it was in whatever class it was in. I don't know how many TVs they had. You remember those TVs on the big carts?
Oh, yeah.
Strapped to the carts? Rolling them in?
Yeah, and the overhead projectors,
Oh,
man.
man. Oh.
Yeah.
Hey.
Yeah, that's great. You're getting excited now.
Overhead projectors.
Yeah. Oh,
I remember how exciting it was. You go through your whole school life with those, and then at some point I was doing some presentation and some teacher saying, if you give me that piece of paper, I can make an overhead of it. And realizing like, wow.
Yeah.
You can make an overhead projection of anything.
Yeah.
Somehow.
And then that's when you decided to go into projection.
And now there's 3D printing.
Yes, I know, right? Yeah, for sure. And nobody uses projectors anymore.
No.
Maybe some people.
Well, now
do.
they make them like pocket size.
Yeah. Yeah, and you could get one to for your iPhone.
Your phone.
Yeah.
Man,
Yeah.
2024.
Yeah.
What are we doing?
I don't know. All right. Well, thank you for telling me all that. All right. See you later.
Peace out.